Hello and welcome to today's presentation. My name is Scott Breaker-Abeni. I'm a Senior Director at SAP's Channel Go-to-Market Team for Enterprise Information Management. Today's presentation will be, Are you ready for General Data Protection Regulation compliance? Please note that the information contained in this presentation is for general guidance only and provided on the understanding that SAP is not herein engaged in rendering legal advice. As such, it should not be used as a substitute for legal consultation. SAP SE accepts no liability for any actions taken as response hereto. It is the customer's responsibility to adopt measures that the customer deems appropriate to achieve GDPR compliance. Let's look at the key facts about GDPR to remind us of what the regulation is about and how it impacts companies' business for their operations in the EU. In other words, setting the stage for what the major challenges are. In our digital age, it's clear that data has become one of the most valuable resources. The GDPR focuses on regulating its use, and it relates to the personal data of individual persons and ensuring it can be protected. Penalties can be up to 4% of annual global revenue, or 20 million euro, or 2% and 10 million euro, depending upon the details and the severity of the violations. It's not simple, so check the regulation, but in any case, the penalties are large enough to get the attention of almost any organization. In the context of globalized business, the GDPR is broad in its applicability and now impacts a variety of organizations who were not necessarily affected by prior directives. So whether your company processes data within the EU or not, or whether you use a third party to do it for you, you will likely be subject to GDPR requirements if you process or hold personal data of EU residents. GDPR is a long legal document of 99 articles, but let's try to simplify this down to the main pieces. Let's take a look at controllers and processors. Businesses and other organizations invariably will need to process personal data. That could be for employees, consumers, trading partners, or other groups of individuals. Now, this is an EU regulation, so the personal data we are talking about relates to EU citizens' residents known as EU data subjects. But do not think that this affects only EU businesses. It applies to any international organization that will process the data of EU citizens. And the regulation has statements about how that personal data can be transferred to countries outside of the EU. And when we say process data, that could simply mean storing of the data. Some of this process may be outsourced to other organizations. For example, a company may outsource payroll to a third-party firm or to a cloud service provider to host certain business applications. In standard data protection terms, these entities are called data controllers and data processors, respectively. What is interesting for GDPR, however, is that the controller remains accountable and both can be held liable and face penalties. So let's take a look at personal data. So it's all about personal data, and in some cases that data is deemed sensitive personal data. Such terms are more fully defined in the GDPR regulation itself. However, note that GDPR brings personal data up to date with technology advances and now includes IP address location, data, biometric data, and more. Even depersonalized, also known as anonymized or pseudo-anonymized data, data that you think you have obscured by using some key or token, may still be relevant under the GDPR if the individual can still be identified. Example would be by combining with other data sets. Special categories of personal data are defined in Article 9 of the GDPR. Example of that would be data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, or trade union membership, etc. This article also defines the cases where processing can be allowed by necessity or substantial reasons or public interest. Let's take a look at lawful processing. Organizations need to have a lawful reason for processing personal data and should be able to demonstrate this. Note that consent given to use personal data for one purpose does not imply consent for any other purpose, be that now or in the future. If consent is the basis for legal processing, there are others. Then consent must be explicitly obtained for each purpose which the data is to be used. And the amount of personal data must be in the minimum needed to carry out the intended purpose. Here is an example related to processing payroll. Personal data, such as ethnic origin, should not be needed and must be excluded from the data set, even though it may be required for other purposes. Medical history may be needed when calculating sick pay or Social Security benefits, but details of specific conditions must be removed or hidden. Such personal data must be kept accurate and should only be stored for as long as required for the intended purpose. This brings in some interesting considerations about whether other or regulations require you to keep the personal data for longer, perhaps for accounting or for tax reasons. In which case, access to the personal data must be strictly controlled and blocked from other processing. And the regulation has special consideration for data pertaining to children. In general, for anyone under 16 years old, there needs to be a parental consent. Individual rights. The individual is given increased rights to ensure that their data is being processed lawfully. For example, they can request deletion of personal data. This includes backups, archives, and anything that is shared with third parties. And they can request their personal data in machine-readable form and/or have it sent to another company. A very interesting topic of increasing relevance to businesses now planning to use big data, predictive analytics, and machine learning to improve efficiency is around automatic decision-making and profiling. An individual who may be materially impacted by such an automated decision can request an explanation of how that decision was made and request a human intervention to reassess it. Note that businesses generally must not charge for such requests and must respond in less than 1 month. Accountability. This is a very critical requirement in GDPR, and it runs like the golden thread through the regulation. To be enacted in the spirit of the GDPR, it involves establishing a comprehensive framework, a set of principles, and organizations for protection of the data. In consequence, a significant portion of the GDPR regulation relates to the obligation on the data controller to demonstrate accountability, which in turn will apply to any data processors. Organization-wise, in the majority of organizations, a data protection officer, or DPO, must be appointed to ensure the accountability requirements are being met and hence overall compliance with GDPR. They will become the first point of contact for the supervisory authorities and for the individuals whose data is being processed. The DPO does not necessarily need to be a newly hired person. The role can be shared, provided there is no conflict of interest, or the organization may look to some external advisor to provide this function. It is clear that the person performing this function must have the knowledge, support, and authority to do so effectively. They must report to the highest level of management, be given adequate resources to meet GDPR obligations. They must be allowed to operate independently and not be dismissed or penalized for properly performing their task. Examples of how accountability principles for the GDPR are enacted. Running data protection impact assessments, or DPIAs, which are an effective way to help comply with the regulation and individuals' expectations of privacy. They must be carried out when using new technology and when there is a high risk to the rights or freedoms of individuals. This may include decisions made after extensive processing and profiling, for example. Related to DPIA, implementing privacy by design and by default, the technical and organizational measures you implement to show data protection is integrated into your processing activities. This may include staff training on data protection, internal audits of processing activities, minimization of personal data and its use, or providing transparency to the affected individuals, as well as improving security features, etc. You must be able to provide evidence of compliance by maintaining appropriate internal records of processing activities. This would include purposes of the processing, categories of the individuals and personal data, recipients of the personal data, transfers to countries outside the EU, and how that is safeguarded. It also includes things like retention schedules, security measures, and much more. Breach notification. This is when something goes wrong, when the internal organization measures have not prevented a data breach or processing of personal data has been found to be outside lawful purpose. Note that a data breach does not have to mean the loss of thousands of personal records through a cybersecurity attack or from a malicious insider, though clearly that is very bad. A data breach can include somebody seeing personal data that they should not have seen. Perhaps they had too much access in the system, or certain fields are not being masked when displayed in the user interface. In the event of a data breach, the supervisory authority must be notified within 72 hours of becoming aware of the situation. Individuals that are impacted must be informed without undue delay. The level of fine and how that gets applied for various kinds of data breach is not yet known. However, it seems clear that if the organization, the data controller in this case, has serious or systematic weaknesses or failures in its personal data governance framework, that accountability is not being exercised, and the supervisory authorities will take this very seriously. The maximum fine is 4% of annual global revenue, or 20 million euro, whichever is greater. Clearly, no organization can afford that and the resulting loss of reputation, and the consequence for smaller enterprise may be devastating. Demonstrate compliance. Compliance with GDPR involves a variety of strong data protection and security processes, procedures, policies, technology, and oversight. These should be understood and applied in a consistent manner to meet the requirements set out in the regulation. Documenting specific policies and procedures, including codes of conduct relative to the data protection, can be used to show that not only are they in place, but that they have been distributed to and understood by employees and others. And of course, you'll want to map these various activities to specific GDPR requirements to be sure that there are no gaps and that accountability is clear. There is no official GDPR certification or accreditation at this present time, although various working parties are discussing the need and approach for this. Other certifications related to data protection can help demonstrate an appropriate governance and accountability capabilities, and thus adherence to GDPR compliance requirements. So who is involved? This describes the general case, but can vary from an organization to the other. CEO and board of directors will be interested in the impact of GDPR on business processes. Achieve top-to-bottom review of relative personal data being processed within the business processes. Understand the risks and the challenges as well as the opportunities. Employee training about new requirements, creating awareness of how they should be taking notes and recording information about their customers, prospects, and employees. Protecting against GDPR-related fines and the related impact on directors' and officers' liability insurance, and understanding the company's current GDPR risk exposure. The cost-effectiveness of data. Is the company collecting and accessing more personal data than is needed? Check into reducing the amount of data being gathered, because continued accumulation of silos of unused and potentially toxic data increasing the need for encryption and therefore requires more investment. Governance. The Chief Compliance Officer, or CCO, and risk officers, the CRO, are related roles. The CCO and CRO will focus on lawful processing of Article 6 GDPR and accountability of Article 5 GDPR to demonstrate compliance by introducing a clear company-wide data protection and privacy policies to ensure agility to potential breaches and to be able to inform the relevant authorities quickly. Establishing an accountability framework by adding documentation of current risks and controls for the GDPR regulation into existing internal control systems. Incorporating a risk-based approach by assessing the likelihood and severity of risk of personal data processing operations. Example given would be high-risk processing operations. Those will raise additional compliance obligations such as data protection impact assessments, DPIAs, and so forth. Encouraging a culture of monitoring and assessing data handling processes. The Data Protection Officer, or DPO. Most businesses that market goods or services to customers within the EU and collect their personal data must appoint a Data Protection Officer. The DPO works on behalf of the customer's privacy. Thus, the independent mindset of the DPA may make recommendations that run contrary to the aims of other data roles within the company. The Data Protection Officer keeps up on laws and practices around data protection, conducts data protection assessments internally, ensures that all other matters of compliance pertaining to data are up to date, is responsible for advising the organization of their obligations and monitoring compliance, must report directly to the highest level of management, and have expert knowledge of data protection. Can also be outsourced. Operations. Chief Information Officer, CIO, Chief Information Security Officer, CISO, and business process owners. These roles generally deal with keeping the company's data safe and making sure that the troves of data are being exploited to improve business functions across the company. The CSO will define GDPR requirements in the security strategy, manage information risk management, security incidents, and crisis management, be responsible for cybersecurity, including monitoring access of personal data and reporting of data breaches, limit who has access to personal data and make sure that access is authorized and reflects personal changes that happen within an organization. A CIO will typically focus on architecture and fulfillment of new rights of the data subject to Chapter 3 of the GDPR, including data subjects' consent for processing of personal data, which might be revoked at any time. Data subjects' consent for processing of personal data, which might be revoked at any time. Data subjects, customers, subscribers, users, employees, partner, external workforce, will get extended information rights, the right to correct information, the right to export and transfer, as well as the right to be forgotten. Information that is no longer required to be stored for, such as legal reasons, is expected to be completely removed from all storage systems. Can advise the DPO on technical solutions. Regardless of the titles and roles, organizations underlying the EU GDPR will establish comprehensive programs addressing these key data protection areas. The more automated and integrated the program is with existing business applications, audit, and compliance tools, the more effective, cost-efficient, and preventative this program will become. Responding to GDPR requirements is obviously about managing all elements of the data lifecycle to operationalize compliance according to the rules defined in the regulation, but it also is about governing the overall program using assessments and surveys, defining, implementing, and monitoring policies and controls, and managing access to personal data compliantly. SAP solutions for GDPR cover these two aspects of operationalization and governance with two sets of solutions, respectively our database and data management DDM and governance, and risk and compliance GRC portfolios. Here are the core applications that can help you address GDPR requirements. From the GRC portfolio to perform all the necessary assessments and surveys and documents and manage controls and policies to monitor their status and to manage critical access to the data processes where it is used, you have SAP Process Control and SAP Access Control. From the DDM portfolio for enforcing retention, blocking, and deletion rules and capturing and storing, profiling, protecting personal data, you have SAP Information Lifecycle Management and SAP Data Services and SAP Information Steward. In addition to the core solutions just mentioned, you may also wish to consider additional SAP solutions that SAP offers. There are 3 lines of defense that SAP can help you with: access governance, cybersecurity, risk and governance, and the database and data management tools. The business value of SAP solutions extends beyond just compliance with GDPR requirements, which is obviously critical, be it to avoid the costly fines. They can help the business protect value, streamline and automate processes to drive organizational efficiencies, improve governance and accountability, and they can create value by identifying and capitalizing on new opportunities and revenue streams, drive greater customer trust, engagement, and advocacy, and serve as a catalyst for the digital transformation. This concludes the presentation on GDPR. And with that, I would like to say thank you for watching the presentation, and feel free to contact me at scott.breaker@sap.com. Thank you.